Hello students, today we will be discussing the topic of right to freedom of speech and expression vis-a-vis religious speech. Introducing the topic. Freedom of speech and expression has been described as the mother of all liberties. Preamble of the Constitution of India resolves to secure for the citizen of India liberty of thought, expression and belief. Article 19 Clause 1 of the Indian Constitution says that all citizens shall have a right to freedom of speech and expression, to assemble peaceably and without arms, to form association or union, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, to practice any profession or to carry out any occupation, trade or business. Article 19 Clause 1 Subclause A of the Constitution of India states that all citizens shall have the right to freedom of speech and expression. The philosophy behind this article lies in the preamble of the Constitution, where we solemn to secure to all its citizens liberty of thought and expression. The right of freedom of speech and expression implies that every citizen has the right to express his views, opinion, belief and convictions freely by mouth, writing, printing or through any other method. The exercise of this right is, however, subject to reasonable restrictions for certain purposes being imposed under Article 19 Clause 2 of the Constitution of India. Historical development. Concept of freedom of speech can be found in early human documents. England's Bill of Rights 1689 granted freedom of speech in Parliament and is still in effect. The Declaration of the Rights of Man and of the Citizen, adopted during the French Revolution in 1789, specifically affirmed freedom of speech as an unalienable right. The Declaration provides for freedom of expression in Article 11, which states that the free communication of ideas and opinion is one of the most precious of the right of man. Every citizen may accordingly speak, write and print with freedom, but shall be responsible for such abuses of this freedom as shall be defined by law. Article 19 of the Universal Declaration of Human Rights, adopted in 1948, states that everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinion without interference and to seek, receive and impart information and ideas through any media and regardless of frontiers. Today, freedom of speech or freedom of expression is recognized in international and regional human rights law. The right is enshrined in Article 19 of the International Covenant on Civil and Political Rights, Article 10 of the European Convention on Human Rights, Article 13 of American Convention on Human Rights and Article 9 of the African Charter on Human and People's Rights. Based on John Milton's argument, freedom of speech is understood as multifaceted right and includes not only the right to express or disseminate information and ideas, but three further distinct aspects. Number 1, the right seeks information and ideas. Number 2, the right to receive information and ideas. And number 3, the right to impart information and ideas. International, regional and national standards also recognize that freedom of speech and expression includes any medium, be it orally, in written, in print, through the internet or through art form. This means that the protection of freedom of speech as a right includes not only one content but also the means of expression. Importance of freedom of speech and expression. A basic element of a functional democracy is to allow all the citizens to participate in political and social processes of the country. There is an ample freedom of speech, thought and expression in all forms, verbal, written, broadcast, etc., in a healthy democracy. Freedom of speech is granted not only by Indian Constitution but also by international statutes such as Universal Declaration of Human Rights, declared on 10th of December 1948, the International Covenant on Civil and Political Rights, the European Convention on Human Rights and Fundamental Freedoms, etc. This is important because democracy works well only if the people have the right to express their opinion about the government and criticize it if needed. The voice of the people must be heard and their grievances are satisfied, not just in the political sphere. Even in other spheres like social, cultural and economic, the people must have their voices heard in a true democracy. In the absence of the above freedoms, democracy is threatened. The government will become all too powerful and start serving the interest of a few rather than the general public. Heavy clampdown on the right to free speech and free press will create a fear factor under which people would endure tyranny silently. In such a scenario, people would feel stifled and would rather suffer than express their opinions. Freedom of the press is also an important factor in the freedom of speech and expression. The second Chief Justice of India, M. Patanjali Sastry, has observed, freedom of speech and of the press lay at the foundation of all democratic organizations, for without free political discussion, no public education, so essential for the proper functioning of the process of the government, is possible. In the Indian context, the significance of this freedom can be understood from the fact that preamble itself ensures to all citizens the liberty of thought, expression, belief, faith and worship. Liberal democracies, especially in the West, have a very wide interpretation of freedom of speech and expression. There is plenty of leeways for the people to express dissent freely. However, most countries, including liberal democracies, have some sort of censorship in place, most of which are related to defamation, hate speech, etc. The idea behind censorship is generally to prevent law and order issues in the country. The need to protect freedom of speech. There are four justifications for freedom of speech. They are: for the discovery of truth by open discussion, it is an aspect of self-fulfillment and development, to express beliefs and political attitudes, and to actively participate in a democracy. Hate speeches. The meaning of a hate speech in contemporary times has travelled beyond mere offensive speech. It encompasses speech that is insulting, derogatory, discriminatory, provocative, or even such that it incites and encourages use of violence or results in violent backlashes. It results in disturbing the harmony and order in society at large. But more importantly, hate speech becomes a particular heinous type of hate crime, causing direct physical and psychological harm to the victim of hate crime. It affects its victim in intangible ways, leading to chilling effect on the victim right to free speech and expression, resulting in exclusion from participation in the democratic process and public discourse. Black's Law Dictionary identifies hate speech as the speech that carries no meaning other than expression of hatred for some group, such as particular race, especially in circumstances in which the communication is likely to provoke violence. Therefore, it can be said that hate speech is speech that is, broadly speaking, derogatory towards someone else. India subscribes to the latter approach and bans hate speech on the basis of religion, ethnicity, culture or race. Though the term hate speech does not find mention anywhere, but its different forms are identified across the laws that address this kind of speech. Most importantly and primarily, the Indian Penal Code under section 153A, 153B, 295A, 298, section 505 clause 1 and 505 clause 2 declares that words spoken or written or employing signs or any kind of visual representation that promotes disharmony, enmity, hatred or ill will or offense or insults on basis of religion, ethnicity, culture, language, region, caste, community, race, etc. is punishable offense. Following this, there are plethora of laws. For instance, the Representation of People Act, Information Technology Act, Unlawful Activities Prevention Act, and several others. This essentially creates a tangled web of legal provisions dealing with one or other form of hate speech, which make it nearly impossible to comprehend exactly what is that hate speech that is banned within the Indian jurisdiction. Broadly speaking, it is defined in terms of one concentrated expression of sectarian communal ideologies, and second as based on politics of exclusion. Thus, hate speech is defined in India in terms of the harm to the community at large rather than one which is focused on the violation of an individual's right to freedom of speech and expression and the harm done unto her as a result of hate speech. And as laws are also accorded constitutional protection by way of reasonable restriction under Article 19 Clause 2 of the Constitution of India on the fundamental right of a citizen to freedom of speech and expression. On the other hand, the incident of hate speech and related hate crimes have only been on the rise. Though the aim of hate speech law is to ideally prevent hate speech altogether, they have not been very effective in this aspect, and only limited success has been achieved in regulating hate speech in the country. This begs the introspection of our laws and their working, and whether the plethora of laws have actually led to a situation of over-criminalization of hate speech itself in the first place. The Supreme Court of India had asked the Law Commission to make recommendations to the Parliament to empower the Election Commission to restrict the problem of hate speeches, irrespective of whenever made. But the Law Commission recommended that several factors need to be taken into account before restricting a speech, such as the context of the speech, the status of the maker of speech, the status of the victim, and the potential of the speech to create discriminatory and disruptive circumstances. Restriction of freedom of speech and expression. The right to freedom of speech and expression is not absolute and is subject to reasonable restrictions. Such restrictions are necessary to maintain social order. No freedom can be absolute or completely unrestricted. Accordingly, under Article 19 Clause 2, the state may make a law imposing a reasonable restrictions on the exercise of the right of freedom of speech and expression in the interest of the security of the state, friendly relations with the foreign states, public order, decency, morality, sovereignty and integrity of India, or in relation to contempt of court, defamation or incitement to an offence. However, the expression reasonable is not defined. In such absence, each case has to be determined considering the facts and other circumstances. Further, the Supreme Court has held that it is important in this context to bear in mind that the test of reasonableness, wherever prescribed, should be applied to each individual statute impugned, and no abstract standard or general pattern or reasonableness can be laid down as applicable to all cases. However, the courts in India have laid down a few propositions in this regard. Thus, the standard of reasonableness is to be ascertained with due reference to the subject matter of the legislation in question, economic and social conditions in India and surrounding circumstances. Also, the concept and scope of what is reasonable changes with time and observe the current socio-economic values. Thus, Article 19 Clause 2 explains the circumstances in which the right to freedom of speech and expression can be suspended. In People Union of Civil Liberties versus Union of India, the Honorable Supreme Court held that the reasonable restrictions can be imposed on the freedom of speech and expression in the interest of security of the state. The term security of the state has to be distinguished from public order, for security of the state refers to serious and aggravated form of public disorder such as rebellion or waging war against the government, insurrection. Another situation is where it hampers the friendly relation of India with other state or states or public order. In case of Ramesh Thapar versus State of Madras, it was held that public order is different from law and order and security of the state. The expression public order connotes a sense of public peace, safety and tranquility, and anything that disturbs public peace disturbs public order. But mere criticism of the government does not necessarily disturb public order. A law which punishes the deliberate utterance hurting the religious feeling of any class has been held to be valid and reasonable restriction aimed to maintain the public order. Further, Section 292 to 294 of Indian Penal Code 1860 provides instances of restrictions on the freedom of speech and expression on the grounds of decency and morality. Section 292 of IPC 1860 read as follows: sale etc. of obscene books etc. For the purpose of subsection 2, a book, pamphlet, paper, writing, drawing, painting, representation, figure or any other object shall be deemed to be obscene if it is lascivious or appeals to the prudent interest of its effect, or wherever it comprises two or more distinct items, the effect of any one of its items is, if taken as a whole, such as to tend to deprive the corrupt persons who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it. Whoever imports, exports or conveys any obscene object for any of the purpose aforesaid, or knowingly or havingly reason to believe that such object will be sold, let or hire, distributed or publicly exhibited or in any manner put into circulation, or take part in or receives profit from any business in the course of which he knows or has reason to believe that any such obscene object are, for any of the purposes aforesaid, made, produced, purchased, kept, imported, exported, conveyed, publicly exhibited, or in any manner put into circulation, or advertises or make known by any means whatsoever that any person is engaged or is ready to engage in any act which is an offence under this section, or that any such obscene object can be procured from or through any person, or offers or attempt to do any act which is an offence under this section, shall be punished for first conviction with an imprisonment of either description for a term which may extend to 2 years, and with fine which may extend to 2000 rupees, and in the event of a second or subsequent conviction, with imprisonment of either description for a term which may extend to 5 years, and also with fine which may extend to 5000 rupees. Exception: this section does not extend to any book, pamphlet, paper, writing, drawing, painting, representation or figure, the publication of which is proved to be justified as being for the public good on the ground that such book, pamphlet, paper, writing, drawing, painting, representation or figure is in the interest of science, literature, art or learning, or other object of general concern, or which is kept or used bona fide for religious purpose. Any representation, sculptured, engraved, painted or otherwise represented on or in any ancient monument within the meaning of Ancient Monument and Archaeological Sites and Remains Act 1958, or any temple or any car used for conveyance for idols, or kept or used for any religious purposes. Also, section 293 of IPC 1860 read as follow: sale etc. of obscene object to young person. Whoever sells, lets or hire, distribute, exhibit or circulate to any person under the age of 20 years any obscene object as is referred to in the last preceding section, or offers or attempts so to do, shall be punished on first conviction with imprisonment of either description for a term which may extend to 3 years, and with fine which may extend to 2000 rupees, and in event of subsequent conviction with imprisonment of either description for a term which may extend to 7 years, and also fine which may extend to 5000 rupees. Lastly, section 294 reads as follow: obscene acts. Whoever does any obscene act in any public place or sings, recites or utters any obscene song, ballad or words in or near any public place shall be punished with imprisonment of either description for a term which may extend to 3 months or with fine or with both. However, the standard of morality changes with changing time. What was considered as obscene or against morality a few decades or years back would not necessarily be considered same in today's time. Further, the standard of morality is not same for each person or group of persons. In case of Ranjit D. Udeshi versus State of Maharashtra, the Honorable Supreme Court upheld the conviction of a bookseller who was prosecuted under Section 292 of IPC for selling and keeping the book Lady Chatterley's Lover. Another ground for contempt restriction is contempt of court. This restriction does not allow any person to indulge in contempt of court by claiming Article 19 as a protective shield. In EMS Nambud versus T.N. Nambiar, the Supreme Court confirmed the decision of the High Court, holding Mr. Nambud guilty of contempt of court. In M.R. Prashar versus Farooq Abdullah, contempt proceedings were initiated against Chief Minister of Jammu and Kashmir, but the court dismissed the petition for want of proof. In both the cases, Honorable Court did not allow Article 19 Clause 1 Subclause A as a defence against the charges of contempt of court. Again, in Re Prashant Bhushan and others, the court found that senior advocate Prashant Bhushan guilty of criminal contempt, and the court observed that the scurrilous allegations, which are malicious in nature and have the tendency to scandalize the court, are not expected from a person who is a lawyer of 30 years standing. In our considered view, it cannot be said that above tweets can be said to be a fair criticism of functioning of the judiciary made bona fide in the public interest. It was further held, in our considered view, the said tweet undermines the dignity and authority of the institution of the Supreme Court of India and the Chief Justice and directly affronts the majesty of law. The tweets, which are based on distorted fact, in our considered view, amount to committing of criminal contempt. The bench added, if such attack is not dealt with requisite degree of fairness, it may affect the national honour and prestige in the comity of nation. Fearless and impartial court of justice are the bulwark of healthy democracy, and the confidence in them cannot be permitted to be impaired by malicious attack upon them. Other reasonable restrictions on the freedom are those that of defamation, incitement to an offence, sovereignty and integrity of India. Clause 2 of Article 19 prevents any person from making any statement that defames the reputation of another person. Such other person may either be living or dead. Section 499 and 500 of IPC covers defamation. Although truth is considered as a defense against defamation, but the defense would be helpful only if the statement is made in public interest. Article 19 Clause 2 also prohibits a person from making any statement that incites people to commit offence. Another restriction, sovereignty and integrity of India, is aimed to prohibit anyone from making the statements that challenges the integrity and sovereignty of India. Accordingly, Section 2 of the Criminal Law Amendment Act 1961 makes penal the questioning of the territorial integrity or frontiers of India in a manner which is or is likely to be prejudicial to the interest of the safety or security of India. Concluding the topic, expression through speech is one of the basic guarantees provided by civil society. However, in modern world, right to freedom of speech and expression is not limited to express one's view through words, but it also includes circulating one's view in writing or through audio-visual instrumentalities, through advertisements and through any other communication channel. It also comprises of right to information, freedom of press, etc. It is a right to express and self-realization. Two big democracies of the world, that is America and India, have remarkably protected this right. As far as India is concerned, This important right is mentioned in Article 19, Clause 1, Subclause A, which falls in fundamental right category. Indian courts have always placed a broad interpretation on the value and content of Article 19(1)(a), making it subjective only to the restriction permissible under Article 19, Clause 2. The word "in the interest of public order" as used in Article 19 includes not only utterances as are directly intended to lead to disorder, but also those that have the tendency to lead to disorders. There should be a reasonable and proper nexus or relationships between the restriction and achievement of public order. Initially, the American Constitution was not having any provision directed to protection of freedom of speech and expression. It was inserted in the Constitution-wide First Amendment of the Constitution. The First Amendment has been drafted in broad and sweeping terms, and for this reason, the text to the First Amendment does not contain any standard for determining permissible restriction on freedom of speech. The restrictions that are permissible now are those that have been developed by Supreme Court in its first interpretation of the First Amendment. The United States has a complex First Amendment jurisprudence that varies the protection offered free speech according to form. Similarly, India developed its own free speech jurisprudence that applies a reasonable restriction test based on 8 mentioned restrictions. The real difference is freedom of speech enjoyed in United States and in India is a question of degree. This degree in difference is attributable to the reasonable restriction, provision and the moral standards of the community. Thank you and have a nice day.